A federal judge has issued two rulings in two important cases involving vaccine mandates at public universities in Michigan. We're going to take a look at those in just a moment, but first, I'm Adam D'Angeli from the Rescue Michigan Coalition, a grassroots leadership organization dedicated to empowering grassroots leaders with the tools and training to be effective in their communities, and also commenting on and helping steer the discussion on critical issues of election integrity, health freedom, and of course, opposing the COVID-19 related lockdown policies that have devastated our state over the past year and a half. So let's get right into it. This is the news story. Western Michigan University can't force soccer players to get COVID vaccine, judge rules. And in fact, I can show you part of the actual order right here. It's 7 pages. The person that posted this on Twitter only showed 3 of them, but they convey the story. So this is an order granting a motion for a temporary restraining order. I'll explain what that means in just a moment, but first let's just go through the background of this case. Plaintiffs are 4 members of the women's soccer team at Western Michigan University. On August 12th, around 6 o'clock, the athletic director sent a text requiring all individuals involved in the athletic department, including student athletes, receive one of the COVID-19 vaccines by August 31st. Plaintiffs each submitted requests for religious accommodations, explaining that their sincerely held religious beliefs would be compromised if they were to receive the required vaccination. Western Michigan University denied their request, asserting the university's quote-unquote compelling interest, and explaining that, quote, prohibiting vaccinated members of the team from engaging in practices and competition is the only effective manner of accomplishing this compelling interest. So that's Western Michigan's argument. And it also states that the players will not be able to participate in intercollegiate sports. They also state the players will not lose their scholarship for the academic year. So then there are missing pages, but we get to the bottom of the document here, which says the court grants the plaintiff's motion for a temporary restraining order. Plaintiffs have established a likelihood of success on their claims that Western Michigan University's denial of a religious exemption from vaccine requirements for student athletes violates plaintiffs' right to free exercise of religion. So the defendants, the university, is enjoined, prohibited from enforcing a COVID-19 vaccine requirement against the plaintiffs. The university may not prevent plaintiffs from participating in team activities for the reason that plaintiffs have not received a vaccine. So long as plaintiffs have not received a vaccine, defendant may require plaintiffs to submit to COVID-19 testing weekly or more frequently, and may also require plaintiffs to wear face coverings during team activities. That's going to be a setback. I hope they challenge that even, but as I'm going to explain in a second, this is still a huge victory at the temporary restraining order stage. So it says defendants may file a response to plaintiff's motion by Friday, September 3rd. So the university is going to respond to this order. They have until tomorrow to do so. Plaintiffs may file a reply to the defendant's response by next Tuesday, and the court will have a hearing on the injunction beginning at 1:30 p.m. on Thursday, September 9th at the court address, the Federal Building in Kalamazoo. So, for those of you who aren't familiar with it, I'll explain what a temporary restraining order is. What the court is doing is it's saying this case was just filed, and we haven't yet had a hearing on it. We haven't yet had a discussion on the constitutionality of the university's policy. But until we have that hearing, in the meantime, the university may not prevent the students from participating in sports. Now, a temporary restraining order like this typically requires a very high standard of review to be granted. That's why they were outlining at the end here that plaintiffs have a likelihood of success. That's one of the tests of getting this preliminary injunction, is that you have to show you have a likelihood that you're going to win your case. They also have to show that there is more of a compelling interest in the students having their rights upheld by the court than having the university trample over them. And that's, I guess, an editorialized way of saying, but basically what we're saying is the harm to the plaintiffs not getting this relief is greater than the harm to the defendants to not have granted the relief. So when courts deny these kind of motions, they'll usually emphasize that it's a very high standard to meet, because the parties haven't had the university hasn't even had a chance to respond to the claims yet. But therefore, when a judge issues an order like this early in the process, it's a strong indication as to where he's leaning on this. It shows that he's got a very strong sense that this is probably a good case. So it says in the article, the judge granted the restraining order. His ruling was based on his discernment that Western Michigan University's vaccination requirement for student athletes is not justified by a compelling interest and is not narrowly tailored. However, the article goes on to note that the same judge, also denied a motion by an employee of Michigan State University challenging that school's broader mandate. We looked at that case in one of our most recent videos, so I'll put a link in the description if you haven't already seen that. That lawsuit was also just filed just a few days ago. And in that case, the judge says he would not grant the temporary injunction. And there's a hearing for that set for September 9th. And as it says here, let's see here. Okay, this is a separate case here in the article. The judge said a Michigan State Supervisory Administrative Associate and Fiscal Officer failed to show she is substantially likely to succeed in the merits. He cited federal rulings in favor of Indiana University's vaccine mandate. This is also a preliminary matter. This case has not been fully litigated yet. The only thing that's happened is that Amy Coney Barrett decided that she didn't want to intervene in that case. And Gina Norris, that's the plaintiff in the lawsuit we looked at in the other video, had COVID-19 and is an at-will employee with, quote, no constitutionally protected property interest in her employment position. She is unlikely to show that MSU's requirement is not, quote, rationally related to a legitimate governmental interest, i.e. the health and safety of the public, wrote the same judge. This is a bad decision, but again, it's only on the preliminary injunction, so it's to say there might be a hearing. Now, you'll recall if you've been following our videos or you're on the Rescue Michigan email list, we've been saying for a long time that the most important and powerful talking point about these vaccine mandates is the fact that they don't give exemptions for people who have natural immunity because they've survived COVID. And every study has shown that natural immunity is more effective than the vaccine. Yet the government insists at every turn, they say it is not acceptable to have immunity as an excuse to not get the vaccine. That just proves they don't care about public health. It's all about controlling your body. It's the giveaway. And I think this statement goes right to that point. This is something that the lawyers are going to have to slam on. And they did bring this up in their original lawsuit. So they have preserved that argument, and they should, I think, slam on that intensely, because the court is saying they're unlikely going to be able to show that's not rationally related to a legitimate government interest. And to me, this is the proof that it is not. Because if it was rationally related to a government interest, they would say your natural immunity is actually better than a vaccine. You can't say that someone has to take an experimental vaccine for the purpose of preventing the spread of the virus when the immunity that they already have is better than the immunity that people have from having the vaccine. So that's something they're going to have to slam on. So that's where those cases are now. This all happened very quickly. These cases were all just filed days ago, but the court's already giving us a preview of what arguments they're interested in and what arguments that we're going to have more difficulty with. But as I say, my recommendation, and this is why it's always important to message your issue smartly, is the most important thing is the way that you show that these requirements are not made in good faith. They're made in bad faith, is the fact that they will never allow an exemption because of your already existing natural immunity. That is the proof that they don't care about public health. It's all about controlling your body. But what do you think? Leave a comment in the description. Let us know if you have any news. Oh, by the way, there's one other thing I wanted to touch on here, because this is, after all, Newsweek, and they can't help but inserting propaganda into every single one of their articles. So they make this unrelated story here. Leaders of two public health associations issued an open letter urging community leaders to support local health officers who have been threatened for issuing orders to curb COVID-19, such as countywide school masking requirements. A Grand Blanc woman was charged last week with threatening to kill two Genesee County health officials. So, despite their dedication and profound sense of duty to protect the public, medical and administrative health officials have been physically threatened and politically scapegoated, wrote the president and past president of the Michigan Association of Preventative Medicine and Public Health. And they condemned the physical threats of intimidation, which leads to this interesting story. A woman is facing a 20-year felony for an alleged death threat over the mask mandate. Now, if you'll recall on our channel, On our website, we've talked a lot about the case of Lucas Gerhard, who is facing the same charge. And his only crime was posting a photo of his lawfully owned rifle and joking that it would make snowflakes melt. So this woman's been charged, is facing a 20-year felony for making a false threat of terrorism. But notice what they claim is going on here. So the prosecutor says the caller identified herself as Rosa Parks and said that we know where the health director and deputy health director live. They intend to leave their children alone or they're going to kill them. Or they need to leave their children alone or they're going to kill them. That certainly sounds like a legitimate specific threat of terrorism to me. But is it true? The defense attorney describes his client as an all-American woman concerned about her kindergartner's well-being. He goes on to claim that at no time in her phone call to the health department did she ever threaten anyone or discuss violence. So one of those statements is not true. And I'd be sure interested to see where this case goes. Because it probably will go to discovery, and we're probably going to be able, at some point, to find out whether or not this threat was true. I tend to be suspicious, because why would a defense attorney claim that there was absolutely no threat made on the call if there actually was? You know, that'd be a weird thing to say. If you couldn't prove it, why would you say it? I guess you could argue, why did the prosecutor say it? Someone here is lying. But the other thing is, all the time we see people saying, I've received death threats, and these are plays for sympathy. And often they're not specific death threats. And the perfect example is this Lucas Gerhard case, where he obviously did not threaten anybody. He made a joke among friends that his rifle would make snowflakes melt. And someone called that a death threat, and he's been persecuted ever since. He is still, to this day, under house arrest, still hasn't gotten his day in court. So anyway, that's just an interesting side note here, but let me know what you think about these cases. We're going to definitely be keeping an eye on them. These are foundational lawsuits. So it's going to be very interesting to see where they go and where the judge ultimately lands, what arguments the attorneys make. So stay on top of this. There's going to be hearings coming up in just the next week. This hearing is on September 9th, and the other hearing I think we saw was going to be on September, no, they're both on September 9th. Or maybe this one's referring to the other. It's hard to say. But stay tuned. We're going to see where this all goes. As always, thanks for all that you do for liberty. Until next time, peace.